and welcome everybody. Welcome Rob, welcome Asher. And we should all send some hope that Rob recovers his cell phone, which he left in the back of the taxi this morning. And admirably is still going to debate, even without this appendage of his. So just to give you a brief overview of how the debate is going to go, I'm going to first just set up in as little time as possible the factual background of this debate and the background of Omar Khadr and a little bit of background on his legal saga. Then we'll have opening statements from Asher and Rob, 10 minutes each. The debating proposition is that the Justin Trudeau's government's decision to award Omar Khadr a $10.5 million settlement in July 2017 was an error in law and policy. Arguing in favor of the proposition is Asher, arguing against is Rob. So they'll have 10 minutes each for opening statements, then they'll have 7 minutes each for reply statements. Then I will ask one question to each of them to kick off the Q&A, and we'll have the remainder of the time for Q&A from all of you. So, briefly, Omar Khadr was born in 1985 in Canada. He was taken as a child to Afghanistan by his family, so most of his childhood was spent there, although he is a Canadian citizen. In 2002, when he was 15, he was shot 3 times in a battle with American troops in Afghanistan. He lost the sight in one eye. He was taken and captured and taken to Guantanamo Bay, where he's accused of killing an American soldier and medic with a grenade. In 2003, while he was in custody in Guantanamo Bay, at 16 years old, investigators from the RCMP and CSIS interviewed Omar Khadr at Guantanamo Bay. In 2004, Khadr filed one of various and frequently amended suits against the Canadian government, initially seeking $100,000 in damages for failure to repatriate him, other claims that would be later amended, the most serious of which eventually was conspiring with the Americans in his alleged torture at Guantanamo Bay. In 2005, a federal court judge in Canada said Canadian agencies, including CSIS, violated Khadr's rights by giving information from interviews with him to U.S. investigators. Later in 2005, the U.S. military charged Khadr with conspiracy, attempted murder, and aiding the enemy. In 2008, Khadr alleges he was threatened with rape and violence by interrogators at Guantanamo Bay seeking a confession. Also in 2008, the Supreme Court of Canada issued a ruling which concluded that Canadian officials illegally shared information about Khadr with the U.S. And that the regime in place at Guantanamo Bay constituted a clear violation of Canada's international human rights obligations under Section 7 of the Charter. And they held that there was a sufficient connection between the government's participation in the illegal process and deprivation of Khadr's rights to life, liberty, and security as a person. In 2010, the Supreme Court of Canada overturned a Federal Court of Appeal court order that the Canadian government should repatriate Khadr, despite agreeing that his human rights were violated. They stated that Canadian interrogation of Khadr at Guantanamo offended the most basic Canadian standards of the treatment of detained youth suspects. In 2010, Khadr pleaded not guilty to 5 war crimes charges, including murder, in a U.S. military court. Judge Colonel Patrick Parrish ruled that his confessions were admissible. In 2010, Khadr changes his plea. The first plea was in August 2010. Later in October 2010, Khadr changed his plea to guilty on all 5 counts. No doubt a strategic move. He gets the opportunity to transfer to a Canadian prison after 1 more year at Guantanamo. In 2012, the U.S. Defense Secretary signed off on Khadr's transfer. He was brought to Canada and sent to Millhaven Institution, which is near Kingston, a maximum security prison near Kingston. In 2015, Khadr was eligible for statutory release after serving 2/3 of his sentence as a youth. And on July 4th, 2017, of course, sources in the media say that the federal government reached an agreement to pay Khadr $10.5 million for damages and apologizes to settle his ongoing lawsuit against Canada. So, has that set us up acceptably well to talk about the issue at hand?
Yes.
So I will pass it over to Asha.
Okay, well, first, thank you, Joanna. Thank you to the Runnymede Society, to Victor for organizing this, and thank you to all of you for coming today. I think this is a good turnout. And thank you, Joanna, for setting that up, because there are a lot of facts in this case, and I would probably have to use up all my 10 minutes just to really go through them. I am not going to be taking the position, just to get this out of the way, that Omar Khadr's Section 7 rights were not violated. The Supreme Court said they were violated. That issue has been put to rest. And unfortunately, this debate has been improperly framed, I think, by both sides of our elected politicians. On the one side, you have people who are saying, well, he was a terrorist, he's a jihadist, so the charter shouldn't apply to that, and he was in Guantanamo, and the charter shouldn't apply extraterritorially. And that's wrong. The charter applies to everybody. If Canadian officials abuse someone overseas, the charter definitely applies. But on the other side, you have people saying that because there was a charter violation, that fact in and of itself justifies a $10.5 million settlement. And that is a logical leap and a legal leap that you just can't make. And so what I'm going to be arguing today is that, notwithstanding the fact that there was a Section 7 violation, that the government's decision to pay him $10.5 million was completely outside what he was likely to get at trial. And that's really the only way you can approach this. So I'm, as Joanna said, or I think it was Victor, I'm a civil litigator. And I don't know if any of you are interested in civil litigation, but a huge part of what you do is assess files, report to clients. And so I tried to do that as best I could with this case. We all have our personal views, but the so-called truth isn't what wins or loses trials. It's facts that win or lose trials. It's evidence. And I've seen enough people get way more than I thought they should get. I've seen enough people get way less than I thought they should get. So I really just wanted to approach this based on the evidence we know now. And what I know is limited because maybe the government hasn't come out with everything. But based on what I and the public know, based on the legal principles, what would likely have happened if Omar Khadr had gone to trial? So the first thing is that everyone has sort of talked about the charter. The charter was not going to be the biggest part of this trial. As Joanna said, Omar Khadr's initial statement of claim only saw $100,000. It was only in 2013 when he added all these private law causes of action that it got amended to, I think it rose to $20 million at that point. And at that point, the charter damages were pleaded in the alternative. So the main focus of his claim was conspiracy. And then in 2014, he had a huge motion with the Canadian government. They opposed him amending the claim to add conspiracy. And this turned into a huge motion, and both sides recognized that this was going to be the meat of his claim. And so the Canadian government fought him on it and lost. So the claim was going to be able to go forward. But losing that motion just meant that the claim wasn't so obviously devoid of any merit that it could proceed to trial. The problem was, had it actually gone to trial, in my opinion, there's zero chance it would have succeeded. And the reason is that, first of all, the United States was not sued. And the reason the United States was not sued was because of sovereign immunity. And because the United States was not sued, they were not going to be discovered. They were not going to be examined under oath. And so to prove any kind of collusion with the United States would have been extremely difficult for Khadr's lawyers. Like that is just a very sort of basic point in any conspiracy case. You need to have both actors there, and you need to get documents from both sides to prove collusion. They were not going to be able to get anything from the United States. The second thing is to prove a conspiracy claim at law. You need to be able to show that both conspirators knew that harm was going to result from their conspiracy. There has to basically be almost, not quite an intention to cause harm, but there needs to be sort of an understanding. And the last thing you have to prove is that the plaintiff not only suffered damages, meaning injuries or some kind of impecuniary loss, but you also have to prove that they suffered out-of-pocket losses, because civil conspiracy is usually brought in a commercial context. It's usually two companies are conspiring to injure a third company, and so the only way that the third company can win is if they show that they actually have a financial loss. So Khadr was going to have to prove some financial loss. So you back that up and you say, so he was going to have to prove that not only that Canada made a mistake, but that Canada conspired with the US, knowing that he was going to be harmed by this, and he lost money because of it. Like, just think about that from a common sense point of view. That's a very hard claim to prove at trial. And that was the meat of his $20 million claim. Now, he also had other parts of his claim. He had a public misfeasance claim. For that, he would have had to prove it even more. He would have had to prove that there was a real intention to injure him. And with both misfeasance and conspiracy, the government could have argued that notwithstanding that they breached his Section 7 rights, that at the time they were acting in good faith, they didn't realize what they were doing was contrary to Section 7. It was a crazy time. It was after 9/11. Yes, we realize now we breached his rights, but at the time we were really acting in good faith. We didn't realize that we were going to injure him in this way. I'm not saying they would have succeeded on that, but it would have been another argument open to Canada. The other thing he was arguing was negligence. This, again, would have been very difficult because, have all of you taken tort law? Okay, so you know negligence at the duty stage, you got the ends, can, loops test, right? You got to show foreseeability, proximity. Okay, so that's easy. But then you have the second public policy consideration. Do we want to create a new duty? And the judge who actually heard his motion to amend the claim acknowledged in the motion that that was going to be really hard, that there's no duty right now between intelligence personnel and people they're interrogating to ensure that they don't injure those people. There's no private law duty there, that it's a regulatory issue, it's a human rights issue, but it's not a negligence issue. And we can think of a lot of public policy reasons why a court would not want to say that all intelligence personnel have a duty to anyone they're interrogating ever. I don't know if they would have affirmed that duty, but that in itself probably would have had to go to the Supreme Court. And then the other problem in negligence is that the Supreme Court has said that your damages for your pain and suffering are capped at about $350,000, $360,000. So that's a lot less than $10.5 million. So those were Khadr's sort of big private law claims. That's where he was hoping to get his $20 million from. And as impartial as I can be, as objective as I can be, my assessment was that there's no way he was going to get that money. In the charter realm, again, people talk about the violation, therefore there's damages. Well, the Supreme Court, yes, it found there was a violation. It also found in 2010 that it could not award a remedy to Mr. Khadr based on that finding because of issues to do with executive privilege. So Khadr would have to have relitigated that issue, and right off the bat, if I'm the lawyer for the Government of Canada, I would have brought a motion saying that's res judicata, that's issue estoppel, the Supreme Court has already decided that you can't have a remedy here. Now, maybe they would have said, well, circumstances have changed, he was in Guantanamo at the time, now he's back in Canada, maybe that would have been relitigated. But even if you had been successful on that, there's a whole test the Supreme Court, or that any court has to go through, in whether someone gets charter damages. And a colleague and friend of mine, Mark Mancini, who's written an article for Advocates for the Rule of Law on this, he went through all the charter cases that have awarded damages. And the vast majority of them, by the way, the vast majority don't award any damages, but of the ones that do, the vast majority award damages sort of in that $5,000, $10,000, $15,000, $20,000 range. It's usually meant to sort of be this extra nominal thing. And, you know, if you want big bucks, you bring a private law claim, which is what he did. He sued for $100,000. Then he decided, no, I want $20 million, so he amended his claim for $20 million and added all these private law claims. The highest award ever in Canadian history is Ivan Henry, who was wrongfully imprisoned for 25 years. I think whatever you think about what Canada did to Khadr, not what Khadr experienced generally, but what Canada specifically did, what the Supreme Court found that Canada did, which was interrogating him twice and sharing that information with US authorities, that is not as bad as someone being wrongfully imprisoned for 25 years. And that decision was a lower court decision that was never appealed. We don't know what an appeal court would have done with it. It's a huge outlier. I think, as far as I know, there's only been 3 decisions ever that have eclipsed $1 million in Canada. Most are about $5,000, $10,000, $15,000. So that's the sort of framework that I'm working with in assessing this. And so when I then hear the Prime Minister say that this was going to cost $40 million, $20 million to Khadr and $20 million in legal fees, that strikes me as outrageous. And if someone, I imagine a lawyer gave him that advice, that he didn't just make that up. And so I think either that's bad legal advice that he received, because it was just not going to be a $20 million case, or there's information that we don't know about that would have come out of trial. And that is another problem. If there's information that we don't know about, that's something Canadians deserve to know. Like I said, I can only assess this based on the evidence. So let's say Khadr was tortured by CSIS, and that fact has been kept, hush-hush. We need to know about that. But based on the evidence that we have, my view is that this was going to be $10, $15, $50, maybe $100,000 that he could have won at trial. Far, far short of
a great turnout. Appreciate the interest, and thank you as well to the Runnymede Society for hosting and for Asher's opening comments. As Victor mentioned, I'm a lawyer at the Canadian Civil Liberties Association. We have had some numerous associations with Omar Khadr's case over the years, including we were interveners in the 2010 Supreme Court case. And I am making the case for settlement, and I want to sort of specify what that means. So partly I'm making the case for settlement today, which is the settlement for today, which is 13 years after the lawsuit was first initiated. And in part, I am making the case for settlement in a case where I do think the government was almost certain to incur some liability. I certainly think there's quite a bit of disagreement on what the exposure was here. I mean, what kind of quantums of damages were truly at issue. I agree with Asher's analysis that it was very unlikely that the quantum for damages would hit $10.5 million. But as I hope to show, I do think it'd be more than the 100,000 or so range. I think even on charter remedies in the recent last couple of years, there's been a movement towards increased charter damages, but also I think this is a remarkable case, and that would have affected any charter remedy. So what I want to get into, I also want to just clarify, I'm sort of saddled with making the case for settlement, but I'm also I'm partly here representing an organization, the Canadian Civil Liberties Association, and we were in favor of settlement for one reason, and I'm going to go into that reason right away, but I don't think that is the reason this case settled. So I want to just clarify that I'm going to be making 3 cases for settlement. Only the first one is really, I think, more of a CCLA position. And so the first reason I think that settlement was sort of appropriate and just here was that, I mean, just simply stated, there was a charter breach, and a charter remedy is appropriate in the circumstances. Now, at minimum, in 2010, the Supreme Court found in a unanimous bench decision that Omar Khadr's Section 7 rights were breached. I think that in the current suit that there would be more in terms of charter breaches that the suit might find, but at very minimum, I think taking responsibility for this charter breach was the right thing to do, and that we shouldn't fault the executive for vindicating charter rights. And so that'll be the first set of reasons. The latter 2 reasons are reasons I would give if I was a DOJ lawyer and I was advising on whether or not settlement was the right tack. Now, as I mentioned, I don't think the quantum would get to $10.5 million in terms of the settlement, but I do think that the basic costs associated with the trial would have easily surpassed $10.5 million. So it made At the end of the day, it made financial sense, that it was cheaper, almost surely cheaper, to settle this case than to continue litigating it. And then the third reason I want to get to, and this is was probably the most powerful motivating factor on the government side, was that there were very serious political costs if this went to trial. So now for just again, for my first set of reasons, I think it's easy to get caught up in the arguments about, Khadr's own action, his own very complicated history. There's been a ton of treatment of this in the media over the years. I don't think that has happened today, but at the end of the day, I think what this suit isn't about is Khadr's own conduct. It's at the heart of the settlement is what Canadian officials did and what they failed to do. And again, the facts here are clear and are supported by not one but two unanimous Supreme Court of Canada bench decisions. So again, on several occasions in 2003 and 2004, Canadian officials interrogated Khadr at Guantanamo Bay, and on at least one occasion they did so knowing that he'd been subjected to the frequent flyer program. So this was the frequent flyer program, for those of you who aren't familiar. Well, in Khadr's case, it was 3 weeks of scheduled sleep deprivation, specifically designed to make detainees more compliant and break down the resistance to interrogation. The CSIS and Department of Foreign Affairs officials, the CSIS officials then shared the fruits of those interrogations with U.S. prosecutors, which, again, the Supreme Court found contributed to Khadr's ongoing detention. So there's no question at the time there's also no question that the time these interrogations were conducted, the regime governing Khadr's detention and prosecution were illegal under U.S. and international law. And there's equally no question that participating in this regime, Canadian officials violated Canada's international human rights obligations and Khadr's chartered rights. Again, these are the facts as found by a unanimous Supreme Court of Canada decision more than 7 years ago. And it's in the face of these findings that the government of Canada refused to seek Khadr's repatriation and instead fought his return. And I think it's also worth noting that every other Western democracy not only sought but secured the return of its citizens held in Guantanamo Bay to their own countries. So Canada alone failed to do so. So I think that, from our point of view, that's the most important reason why settlement was the right thing to do. So it's a remedy for a substantial breach of Omar Khadr's charter rights, a breach that was already recognized by the Supreme Court in 2010. Am I at 7? All right, I will skip what I think is the pivotal passage from the 2010 position that I think would be very favorable to Khadr in his litigation. And again, I'm willing to assume, let's say damages in this case was $1. Let's say you got a quantum of $1 in his litigation. What we know, what the government has already started is that the litigation cost up to this point has already been $5 million. And the problem is that this is an incredibly complicated case. It is yet to go to trial. I think even the full discovery, it was yet to go to trial, and I think even the full discovery process, when it was settled, had not been fully exhausted. And in terms of the cost that would be associated with litigating this kind of case, I think would be far in excess of, would probably at least triple that $5 million figure, and if not more. And a large reason for that, and this gets to the third point, which is the political costs issue, is that in order to enter a lot of the evidence that, in order to, what this trial eventually would have been about is substantial amount of evidence that is currently claimed as confidential information, and would have required Section 838 proceedings under the Canada Evidence Act, which itself is a lengthy and costly affair. So I think that ultimately is what the government was saddled with, going to federal court and to have Section 838 proceedings regarding which information would they be compelled to disclose in order for Khadr's fair trial rights to be litigated. I think quite a bit of that information probably would have been disclosed, and the government had a rather pressing interest not to disclose that information. I think it also, there's also, if they were compelled to disclose that, it's also going to sort of bring them into international affairs territory, etc. So my time here is up, but so I'm happy to hear Asher's response to that. I guess that I think in quite a few respects we're actually maybe agreeing more than a debate.
Okay,
Debater should.
Let's get to the nub of the disagreement. Asher, you have 7 minutes to reply to Rob.
Well, I agree with that we are agreeing in a lot of things we're saying, which isn't necessarily a bad thing. You're all going to be lawyers, and your job is not to take unreasonable positions. Reasonable people can disagree over these things, and I think we're both making reasonable points. I know Rob is, and I think I sound fairly reasonable. I want to talk about this cost issue, though, for a second, because I do disagree with Rob on this. Okay. Yes, the government had spent $5 million to now, but one of the criticisms leveled against the Harper government was that it was fighting this entire case way too hard, that it was opposing him on every motion, it was making life as difficult as possible for Khadr. The Liberals, when they came into power, they could have kept the case going, but they could have sort of taken a middle ground approach. They could have said, look, we are going to keep this case going because we don't think it's worth $20 million, but on the other hand, we want Mr. Khadr to have his day in court, so we're going to stop with all these procedural motions. We're going to fast track this thing to trial. That absolutely could have been done. There's no reason why $10 more million had to be spent. Maybe $1 more million was going to be spent, but even that would be egregiously high. I would want to get on that payroll. I don't think the government would want to hire me, but if even $1 million it costs is spent from discovery to trial, once you've done all these procedural motions, that's a good billing file. I don't think we're going to get 10 million more. The second thing, though, that people have to remember is that the winner of a trial is not just someone who wins $1 or more. Under our rules, if you make an offer to settle, and you beat your offer to settle, so if you're a defendant, the government of Canada, and you offer to settle for, say, let's say you really want to cushion it, you say, let's say $150,000, $200,000, I don't think he's going to beat that. So now you put out a $200,000 offer, and then at trial, let's say he gets $100,000. So he's now entitled to his $100,000, you pay him, but you're entitled to double your costs from the date you made that offer, which would then wipe out his award. So a lot of, you don't really see this in, you don't appreciate this if you read a news story. They talk about what someone was awarded at trial, and it's sort of assumed to be a victory. What you don't know is what offers to settle were made. And so the government could have handled this, first of all, by sort of fast-tracking it and saying, let's just stop messing around and let's go to trial. And second of all, let's put a Rule 49 offer on the table that we think is fair, that we think he would be a fool not to take, and that we think we can beat at trial. They didn't do that. Instead, they just said, let's pay him all the money that he might win and that we would have to spend defending it to trial. I think that's absolutely not a way to litigate. Just as a matter of course, we can talk about the government taking responsibility, but the government also has a responsibility to the taxpayers, and it shouldn't simply be paying millions and millions of dollars on some off chance that it's going to be found liable for that amount and have to pay costs. In terms of political costs, again, that is something I'm not entirely sure on the extent of because we don't know all the facts again. I would say, though, that there would be political consequences for Omar Khadr as well. Everything we've heard from him since the settlement has happened has effectively been that he is very happy that he can now move on with his life. He did not like having this action around. It's not, we'll never know if he threw that grenade. We do know he was building IEDs. I think there's YouTube video or something like that of him building IEDs. We know that he was generally involved. Yes, he was a child soldier, but all of these sort of facts from his past would have come out at trial. They would have come out on cross-examination. That they're not strictly relevant to the charter claim, but they would have been very relevant to other parts of his claim, from contributory negligence to the good faith actions or not good faith of Canada. The context would have mattered. He would have been asked all about that under oath. He did not want to go to trial. Maybe the government didn't want to go to trial, but he didn't want to go to trial either. That is something that needs to be taken into consideration. The other thing is in terms of what Rob's saying about Section 38 evidence applications, that's absolutely true, and the government doesn't want certain things coming out. But of course, this trial could have been effectively closed door. You could have had a publication ban to prevent the media from reporting on certain sensitive aspects. There would have been ways for the government to do this trial without compromising tons of national security. So I don't think that the government was facing inevitable national security revelations or anything like that, unless, of course, again, there might be things we don't know. So I would like the government to come clean and say, here's the bad stuff that was going to come out, or I'd like them to say, you know, we paid the guy too much, because in my mind, one of those two things is correct. So that's all I've got to say in response to Rob. And again, I do think this is a good exercise because, you know, we're sort of teasing out what the main points are here. And I do think that we are mostly in agreement. And I think, Rob, the most important thing, I think, is that he agrees with me. These private law claims were going to be very difficult. I don't, he can respond to that. And that, to me, is the main fundamental reason why he was never going to get $10.5 million or anywhere close to that.
Yeah, no, I mean, I do primarily agree that I think part of what would have happened if this was litigated and some of these negligence claims had gone through, including things like the negligent investigation claim went through, is some of these theories were, I think, novel theories. And would the court have recognized, you know, a specific duty of care it hadn't previously recognized? So would it, for instance, you know, extend the precedent in Hill v. Wentworth about, you know, a specific duty of care in the negligent investigation case between a police officer and a suspect? Would it is it analogous enough to say an CSIS investigator investigating a suspected terrorist, you know, in this situation? Is so there were novel theories that Khadr was pressing, and in order for him to get, I think, a large quantum, he would have had to basically there would have had to have been a development of the law in his favor. But I also want to say, I mean, I think part of the 10.5 million figure, I also think wasn't plucked out of thin air. I mean, I think it's clear that the Arar settlement was, you know, part of, it was something of, it wasn't a legal precedent, but it was something of an informal precedent. So, you know, so for those of you who aren't familiar, Arar had settled for, you know, 10.5 million, I believe, with 1 million in costs, which actually is more than Khadr got once you factor in inflation. But I mean, also you could look internationally. Things like the UK had settled its own Guantanamo Bay cases in a joint settlement for 20 million pounds. And the only theory they had forwarded was this problem of they did not want to disclose confidential information that they said would have defended some of their actions and behavior. So in the interest, in their own national security interests, they paid 20 million pounds, which is, you know, over 30 million. I mentioned that partly to say, I mean, I think I think there's a danger in underestimating when I reference political cost, part of what I mean is that there are very large and important national security institutions that would not go easy with a very quick and dirty trial that attempted to not treat this, not fight tooth and nail. There's a reason this was fought tooth and nail for so long. And I think part of that is it wasn't, it can't, I think even, so even say the Prime Minister is somewhat handicapped in how hard they can press this issue because institutions such as CSIS, et cetera, partly out of, concerns of morale, partly out of concerns of public backlash regarding our national security institutions, just simply would not have gone along with an attempt to sort of treat this more as kind of an economic, let's kind of get this for a lower dollar figure. And I think that's part of why why the deal that was made. In large part rests on those kind of larger, what are political considerations, as opposed to something you might find in kind of a more typical case of litigation. So again, I work at a civil liberties organization, so I don't want to make the point. I'm kind of here on behalf of the side for settlement, but I actually agree with Asher. I will that I think there is a legitimate public concern that that there probably was certain things behind closed doors that we would prefer that the public had more awareness of. And the very fact that the government has been willing to settle, I think, is somewhat of a suggestion that they don't want to reveal information that might, that might be upsetting on a number of public accountability fronts. And I do think that's a large piece of what is going on here. In terms of, yeah, so. I don't know, I feel I'm resolving everything by agreement. Is that so much to say? Yeah, well, one additional thing that I did, I briefly mentioned in my opening comments I didn't have an opportunity to get to. And one thing that was brought up in Asher's opening comments was that, a large part of Khadr's civil litigation suit has this problem of, if it's a conspiracy charge, how do you get evidence about the United States actions? How do you prove the conspiracy? Well, I think that cuts the other way. I mean, part of what that reveals is a lot of the way you would have attempted to prove that would be to compel disclosure from Canada's national security agencies to show what they have on file, what exactly did they do in cooperation with the United States, in what way did they facilitate his continued detention. And if he were to compel that disclosure, and if the Canadian government willingly went to trial and allowed that information to be disclosed, there would be very serious both political and economic repercussions for that. And that it's very likely that there would have been some sort of retribution from the U.S. government if Canada had allowed itself to go to trial knowing that Khadr would have been able to compel. I think he had a credible enough claim that some of this stuff would have been compelled. I mean, partly what he would have been able to do would have been able to compel a number of very high-profile witnesses, including former prime ministers, public safety ministers, a whole host of cabinet ministers, CSIS officials, RCMP, Department of Foreign Affairs. And I think when you go through, each stage of the analysis, what this trial would have been about, including the costs of, these international costs. I mean, I think that was kind of what, led the government to believe that this was the only viable.
Okay, well, thank you. That was excellent. So we went a little over time, but I'm just going to ask two brief questions. First to Rob, you talked about the political costs of the Khadr case going to trial in the sense that it could expose Canada to certain sensitive information, certain compromising details about its executive actions. But what do you make of that counterbalance with the political cost that we know that 2/3 of all Canadians, of all political stripes regionally, across the country oppose this settlement? Isn't that a significant political cost?
A political cost for the Liberal Party, that being...
For the government, I assume the political cost would fall on the government if they were to go to trial as well.
I think I think it's a political cost. I think it's a political cost that is, if we're looking at it in mercenary terms and you're sort of advising the government which political cost is greater, in part because I don't think they would have escaped liability. That, once you get into sort of the legal cost awards, the damages awards, et cetera. So I think there are so many other costs on the other side that it simply outweighs it, including the cost of just continually dragging this case on and being publicly visible as kind of the agent who had been associated with Khadr's detention in Guantanamo, and I think so. It's an unpopular decision, but I think not to be too cynical, but I think people forget, and that's partly why. That's partly why the government wants resolution on this. I think partly it's people forget. They've also. I don't want to be, I guess, too cynical about it either. They have publicly apologized for their actions, and they have. I think it's intended to. It's unpopular in the particular event, but I think there's something. You can make a long-term argument that being someone who's seen as actually standing up and attempting to vindicate charter rights in the long term, it might involve unpopular decisions, but there's something to be said for standing for principle.
Okay, I'm going to skip over my question to Asher and open it up to you guys for questions. So, don't all raise your hands at once. Yes, over here.
I think there's a similarity to the sentiment of people forget the day before Remembrance Day.
Is there a question?
Here, I'll frame that. So, it's taking away your civil liberties hat. The fact that the argument for political capital, that they shouldn't be exposed, it doesn't seem to. Shouldn't, in a democratic society, we have the ability to, observe what our government's doing. If there's an economic cost to that or not. Either we have to look at this from a democratic perspective or an economic perspective or some middle ground, but it doesn't seem like you're fitting either well. Sorry, that did.
So, sort of to choose one. Which should really take priority.
Right.
If we're, in terms of my own position, I do think the kind of the democratic charter kind of perspective should take priority, and that the willingness to sort of accept these kind of costs should win out. Even in the face of it being an unpopular decision. I think it clearly is an unpopular decision, but that's true of charter, I think, charter cases all the time where government is seen as upholding a charter right against, say, law and order type desires for more punishment.
Over here.
Is it not possible to, let's say, for the government to have an undisclosed settlement with the Khadr family, instead of saying $10.5 million, saying we just had a settlement with the family, therefore not disclosing the 10.5, not invoking public outrage, and at the same time resolving everything that this gentleman said?
Asher, that's your.
Yes. You could have had, in fact, most settlements are confidential, like just in everyday litigation, there's often confidentiality clauses. Most settlements don't include apologies either, even though they do often include a lot of animosity and people blaming people, they don't usually include apologies. The fact that the settlement was disclosed isn't necessarily, that doesn't necessarily say the government did something wrong, because the government also wants to be accountable and needs to show how much money it's paying out of the public purse. So it's sort of a, as they would say on Trailer Park Boys, a catch-23 situation. Because you paid, you tell everyone what you paid, and it's a big scandal, and you don't tell anyone what you pay, and everyone assumes the worst and starts saying this is not a transparent government, etc. So you're sort of stuck between a rock and a hard place there. But it could have been confidential, certainly, if they wanted it to be.
Okay, Victor?
I'm wondering if there's value in distinguishing between two types of political cost here, because there's the political cost of the settlement to the elected officials, the Liberal government, and there's the political cost of not settling, I think the way I see it, with the civil service and the unelected officials that reside there. In my mind, I think the Liberals could have actually gone forward with this case with very little political pushback on them, because they could very easily say that this is all attributed to the previous administration. It seems to me that, and I'm wondering if you agree with this, there seems to be, this seems to be very much in the interest of not the elected government, but actually the civil service that surrounds them. And, well, I don't want to be presumptuous, but maybe a sort of quid pro quo deal.
I mean, that would be speculating, but it's interesting, Rob, I think, eloquently discussed a lot of the sort of dirty laundry that might be aired if this thing went to trial. But, and Rob, you mentioned former prime ministers would testify. Well, which former prime ministers would testify? Jean Chrétien and Paul Martin, because that's who the prime ministers were when these interrogations happened. The Conservatives were in power, and even after this claim was amended to add 20 million in conspiracy allegations, so they knew at that moment it's all coming out of trial. The Conservatives were saying no, full steam ahead. The Liberal Party comes into power, and not too long after they settled the case. So I have to wonder, in terms of political costs, are they party political costs or are they national security political costs? If they're national security political costs, then it's the Conservatives who should be faulted for not having that larger scope of thinking, maybe. But if it's partisan political costs, we don't want to put our good old boy Jean Chrétien on the witness stand, so let's pay this guy $10.5 million. I hope no one in this room would support that as a basis to settle a claim.
Sure, in the back.
I read in an article a while back that the widow of the Sergeant Spear is filing a suit for $134 million. How does that affect the settlement money that the government has paid out to Omar Khadr?
Okay, so there hasn't been a suit filed. There's been judgment granted already in the United States, and the way the law works is that if a Canadian court determines that process was fair, and most of the time U.S. judgments are affirmed, then that judgment will get affirmed in Canada, and Omar Khadr will owe $130 million. Now, Omar Khadr didn't have a trial on the merits in the United States, but there'd be a lot of arguments about the fact that he was aware of it, and I believe his lawyers pretty intentionally didn't defend that action. My understanding, and I'm not an expert on that, but my understanding is that they knew about it and they sort of ignored it and they said, we're not going to deal with that right now. There was a recent decision from the Ontario Court of Appeal that affirmed a similar judgment that came out of the US against Iran for something like $10 billion or something, and tons of people who are victims of terrorism, and that was again a US judgment, but because Iran doesn't have any executable assets in the US, they came to Canada to enforce it. And the Court of Appeal set a very important precedent in that case that would be hugely relevant if and when Sergeant Spear's family brings the motion to enforce the US judgment here, which I think they're planning to do. So you can plan on seeing that Court of Appeal case be very relevant for this new suit.
You had a question?
Yeah, so you both talked about the potential for one of the reasons of the settlement being that perhaps there's information that the government doesn't want to public. And that seems to me to be a really troubling precedent to set, especially given that there's now this other suit, very similar suit, that, well, if I just sue the government and there's information that they don't want leaked, they're gonna settle with me for a bunch of money. So on a public policy scale, that seems really problematic and goes against a lot of some of these government principles of transparency and accountability. So I'm just curious about your thoughts, I guess, on sort of the longer term ramifications possibly of that speculation.
Well, I mean, I think the longer term ramifications, one of the things that's been discussed, certainly not something I think we would support, but there's been some discussion about these, when you have the litigation in federal court about the Section 38 evidence, there's been some discussion, instead of having that evidence, sort of then be disclosed, in the civil litigation trial, but instead that basically it closed. Maybe we could do something that isn't an open court, that is instead a closed proceeding, that is never made public. There's other ways to sort of limit disclosure, such as through things like publication bans. I think that's been one way in which I think from the national security position is forwarded. I think it should cut the other way, that it's a recognition that our national security agencies are engaging in behavior that isn't that they aren't completely being overseen for, and that the idea that there is and that there's also a certain benefit for these are sometimes called gray mail instead of black mail, gray mail cases, that they incur a cost on the government for keeping this up, and so that there is that benefit, and I think that the long-term hope is that by maintaining this open court principle as much as possible, that there's a cost to this national security secrecy.
Okay, last question.
My question is just very, very simple. If 2/3 of Canadians are against a policy like this, whatever the law says, I think there's a perception issue of paying out a settlement of this type to someone with this sort of background, whether the rights are aside. In a situation where there is such a perception issue, might it not be beneficial to go to trial with just a general policy of we're going to take this to trial every time and just air it out and say that when issues like this that have perception issues are out there, we're not going to settle and keep information behind closed doors, but we're going to open it up, we're going to go to trial, we're going to make it difficult for them, and we're going to air out our laundry. In terms of political capital, might that be a good way to handle it? I mean, both of you guys, what do you think on this?
I agree with you. The problem is there's always some things we don't know. So only to a point. If there really are damning things that are going to come out about the government, national security things, and they can't be protected with a publication ban, then that's a reason to settle. But in general, I agree with you. I think had the government taken this to trial and lost, and had the cost being, cost and judgment together somehow reached that $40 million, which would have never happened, but had that happened, I think Canadians as a whole would have been more understanding of that. You know, sort of the old, you know, you tried, you failed, and sort of mindset. There's different ways to think about it. I mean, there's another thought that you should always do the cheapest thing possible. You're the government. You're not there to take a moral stand. You're there to manage taxpayer money. So I don't think there's a right answer necessarily.